Hi there. Hopefully you can all hear me. My name is Milligan. I am a partner in the employment team at Harper McLeod. And I am presenting the latest in our series of manufacturing webinars, which is on the impact of COVID-19 on the manufacturing workplace. We are still deep in lockdown at the moment, as if any of you are viewing me, you can tell by my hair. Unfortunately, I can't see any of you. I am talking into the void for the next 45 minutes, hour or so, but I will do what I can. We'll have a few slides for you, and I'll talk through some of the hot topics in terms of what we've been asked about and what we see as potential issues in the future of employment law. As I say, I'm a partner in the employment team. We've spent most of the last year advising clients of various sizes and descriptions about COVID-19 and the response to it. So well versed in dealing with these matters. I should say, when we're going through it, there is an opportunity to virtually ask me a question. I think there's a chat box facility where you can type in a question and these will get picked up and I can answer them either at the time or at the end, depending on what the question is and when I see it. So please feel free to put your questions into me, and if I can assist, I will do. So looking at today's topic, as I say, it's on the impact of COVID-19 on the manufacturing workplace. I am looking at it from an employment law perspective, going to be touching on things like furlough, flexible working, etc. I'm not going to be looking at other aspects of the workplace. I'm sure you're more than familiar with the health and safety requirements and a lot of the precautions and government guidance on that. So I'm not going to be looking at that. It's more a pure employment law focus rather than health and safety or matters within the actual workplace, the physical workplace. So if we just look at the overview slide, what I'll be looking at is government assistance, and that's the coronavirus job retention scheme. Then I'll go on to another thing that we have been asked about quite a lot, unfortunately, over the past 6 to 8 months, redundancies. Having a talk through the difference between individual and collective consultation, key considerations and key points to hit if unfortunately you've got to go through a redundancy procedure. Looking a bit at working from home and flexible working. And finally, looking towards the future and considering as well one of the current hot topics on vaccination. So the first point will be looking at government assistance in terms of the coronavirus job retention scheme. So we just move on the slide. I will start with a furlough update. As per, I'm sure you've all seen the budget yesterday. Furlough was due to end at the end of April this year. Unsurprisingly, it has been extended. That is to the 30th of September of this year, in what I think is the 4th extension to the scheme now. I was actually having a look back, and it was originally put in place for 3 months. I think it was retrospectively put in place from March 2020 to the end of May 2020. It is hard to believe now that that was originally what was envisaged, and it was only going to be required for possibly a 3-month period. Unfortunately, we've all experienced that was not quite the case. So that's the headline point, that it has been extended. There have been multiple iterations of the scheme. It has changed numerous times from May or March 2020 to now. I would imagine the guidance is going to be updated again. It's stayed relatively consistent over the past few months, but the difficulty is the guidance and the Treasury direction are where you find most of the details of the scheme, and they are updated fairly regularly, particularly the guidance, with no particular advertising of this by the government. You've just got to check the website and check for the update section to see what's been updated and when. I will plug our Harper McLeod employment law blog that you can get on the website or Twitter, because every time there's a significant update, we write about it and signpost it. So if you're not signed up to that, please do so, because hopefully it's of assistance in flagging things that may easily be missed. So as I say, the key point is that it has been extended until the 30th of September 2021. The current scheme is contributions of 80% of salary for hours not worked, and that's up to the cap of £2,500 per month. Pension and national insurance contributions are covered by the employer and paid by the employer. That's going to remain until the end of June 2021. Then it's going to be reduced to a 70% contribution by the government in July 2021, which means that the employee will still get their 80% for hours not worked, but the employer has to put 10% towards that. That then changes again in August and September to a 60% government contribution and a 20% employer contribution. This, you may remember, is quite similar to the scheme last year, when it was going to be tapering off and was going to be replaced by the job support scheme. And that was going to be in place, I think, from November 2020. And then because of the effective second wave of COVID, the job support scheme was abandoned, and a revised job retention scheme was put in place. So just a few things to be conscious of and be aware of in terms of ongoing issues or ongoing matters to consider. You cannot make a claim for an employee's notice period, statutory or contractual notice period, under the latest version of the scheme, and the current version of the scheme also. Pre-November 2020, it was unclear, but it was generally accepted that notice periods, if an employee was working their notice, they could still be furloughed, and a claim for up to 80% of their notice pay could be made under the furlough scheme. That's not permitted under the present scheme, and I doubt it will be permitted in the revised scheme also to the end of September. Also important, and unfortunately we've been asked questions by employers that have actually been caught out by this, is that to be eligible, one of the number of eligibility requirements for furlough is that the employee has to have been employed on the 30th of October 2020 or before, which means that for employees that have been hired in November and December, primarily, because that, of course, was before the full current lockdown, or the current full lockdown, rather. Some businesses were hiring employees during this period. Unfortunately, if they're hired after the 30th of October then they don't qualify for furlough. And it would appear, I've not seen anything to the contrary as yet, although the usual lawyer's caveat is the guidance does change all the time, but I haven't seen anything as yet to change that. So any employees employed after that time wouldn't be eligible for furlough. There was also when lockdown happened in January this year, and then there was the announcements that schools were closing as well. There was some uncertainty over whether employees who had caring responsibilities for children could be furloughed. Of course, the purpose of the furlough scheme generally was said to be if an employer is having issues in terms of the amount of work it had available to them, and rather than make employees redundant, they could use the furlough scheme. That had been expanded, the interpretation of that, but it wasn't clear whether or not caring responsibilities fell within furlough. If there was still work to be done, the employee just couldn't do it because they had caring or schooling responsibilities. That was clarified eventually in January that it could be used for those purposes. And that will presumably continue to be the case, albeit hopefully with the schools going back at least partially. That's going to be less of an issue for employers going forward. One thing that we've also been asked of that I think will continue to be an issue is what about employees who don't want to come in to work if there is work for them? Now, whether that's because of health and safety concern or any other concern short of a caring issue, it's not clear. The Treasury direction does say that you are entitled to claim for an employee whose employment activities have been adversely affected by the coronavirus and measures taken to prevent or limit its further transmission. So it could cover potentially an employee who says, I don't want to come in because I'm worried about being infected. And for example, there is a vulnerable person in my household and therefore I don't want to risk it. It's a difficult one. No employer is obliged to use the furlough scheme. It is entirely voluntary. It is there to be used. So it may be able to be used in this case, but it is a bit of a grey area. And to link on to the next point, I think if it is used for anything like that, then it would be appropriate and necessary to have clear records of why it was being used, particularly if there would otherwise be work for the employee to do. And that next bit is the HMRC audit. HMRC are able to audit furlough claims under the coronavirus job retention scheme. So they can review everything. There is an obligation to keep the relevant paperwork, and it is listed online what you need to keep for 6 years. So I would very much consider that perhaps in the spirit of the budget yesterday, there is giving, but then there is potentially taking away. So I would very much expect that HMRC would be looking to audit furlough claims. And I think as part of the budget, there was a dedicated unit announced to crack down, I think in the government's words, on any fraudulent claims, including in relation to the furlough scheme. So just a reminder to make sure that your records are up to date and kept in good shape, because HMRC may be auditing these claims. Also, worth noting is that I think since the change to the scheme from November last year, that there is publishing or publication of the employers who utilise the furlough scheme online by the government, and as well how much they are claiming within certain parameters. And I think that's, again, a sort of suggestion or slight deterrent for people to use the furlough scheme if they don't want to be seen to be using the scheme. We've already seen some employers having paid back rate reliefs and potentially furlough assistance they've received from the government. Some big employers, I think possibly Tesco was one of them. And this is along the same lines. Employers may not want to be, if you like, named and shamed for using furlough. But having said that, they are, of course, perfectly entitled to do so, providing it falls within the parameters of the scheme. I will move on from furlough to talk now about redundancies, which are possibly going to be the outcome for a number of employees who are on furlough at the moment. It may be that, and hopefully not, hopefully the economic recovery will be very good, but there is certainly a chance that employees who are furloughed at the moment will ultimately be made redundant, and therefore employers are advised to consider their redundancy requirements and the redundancy procedure that needs to be followed. I'll look at individual consultation and collective consultation and the difference between them and different things that you need to hit for each of them. Looking at individual consultation, first of all, this is required regardless of the numbers involved and regardless of whether you need to do collective consultation as well. It's, from case law, it's a key point of getting a fair dismissal. Ultimately, as I'll come on to, you can have an absolute cast iron guaranteed redundancy situation in that you don't need employees to do a certain task anymore. But if there isn't a fair process followed, then it's going to be an unfair dismissal of a claim is raised. The value of that claim may not be significant, but it can and would still be a successful claim. So individual consultation, what are the key points? Starting point is the commercial rationale for the actual potential redundancy, and it should only be a potential redundancy at the start of the process. Why do you not require these employees or this employee to do this role anymore? It may be that the role is entirely disappearing. It may be that there's a diminished requirement for a number of employees who are doing that role. It may be you've got 4 employees and you only need 2 employees going forward doing that role because you've got less work coming in. That's fine, but you need to be sure at the outset of what the rationale is for it and why redundancies are potentially necessary. And why that's particularly important is because that's the first thing that an employment tribunal will potentially look at. Was there a genuine redundancy situation? Now, an employment tribunal cannot substitute its view for an employer. So an employment tribunal can't turn around and say, well, actually, we would have dealt with that downturn in work a different way. We wouldn't have gone down a redundancy route. They can't do that. If you can say, well, we had a downturn in work and therefore we needed to make redundancies, or we believed that was the appropriate route, they can't look beyond that. But if you don't have that rationale in the first place, then it becomes more difficult to defend any claim. And more difficult to retrospectively prove that was the reason that you needed to make redundancies. So once you've got your potential rationale or the rationale for the potential redundancy. The next point to consider is who is in scope for the potential redundancy. Is it a pool of employees? Are there a number of employees doing the same job and some of them are going to be made redundant? Or is it a pool that all of them are going to be made redundant? Or is it just a single employee doing a standalone role who is potentially going to be made redundant, which is still a pool, but a pool of one? Pools of one will always be closely scrutinised by the Employment Tribunal to make sure that you are not effectively selecting an employee for another reason and just calling it redundancy. They can absolutely be justified, but it's always appropriate to consider should that pool be wider than just one individual. Pools can go up and down as well as across the way in terms of seniority. And it could be appropriate to pool people in slightly different positions. It is very fact sensitive. But again, providing you can show you've applied your mind to it, it's difficult for a tribunal to second guess and say you were wrong to do that. If there is only one person, this pool of one, or there is a larger pool, but all of them are potentially redundant, then there doesn't need to be a scoring process because all the jobs in the pool are going. If there are a number of jobs going, but more employees than the number of jobs going, so if you're going down, to use the example before, from 4 to 2 employees, then it would be appropriate to score these individuals using, whereas as far as possible, objective criteria. And ideally, the best way to do it would be to have 2 managers scoring independently of each other and then coming out with a combined score. Again, that's to reduce any allegations of bias or that any one person was being chosen or selected in particular. So after you've scored, you would tell the employees their own score. They can challenge their score. This is all forms part of the consultation process. Another key point in the consultation process would be considering alternative employment, and I'll come on to that in more detail shortly. Also, as well as alternative to employment, are there any other actions short of redundancy that might avoid redundancy? For example, reduction in hours. It may be that employees may be willing to work a 4-day week, potentially using flexible furlough, rather than making an employee redundant. So these are the sort of things that can be discussed and considered when considering alternatives to redundancy. The next point in the slide there is the opportunity to appeal. Now, opportunity to appeal and right to appeal is fundamental in the Acas Code when it comes to disciplinary situations and capability situations as well. There is not that absolute requirement to have in a redundancy procedure, but I can't think of a good reason not to have a right of appeal against a redundancy dismissal. So if at the culmination of the consultation there is no way to avoid the redundancy, then certainly dismissal can be the outcome with the appropriate redundancy, statutory redundancy notice and any enhanced redundancy entitlements. But you would always want to give the right of appeal as well against that outcome. As I've already said, failure to consult may render an otherwise fair dismissal unfair. So you can have the most blatant cast iron redundancy situation, but if you don't consult, it's going to be an unfair dismissal. How long an individual redundancy consultation procedure takes does depend on the circumstances, and, for example, depends on the number of employees, whether there needs to be scoring, how the pooling's been done. But as a very broad brush rule of thumb, we would want to see at least a 2-week consultation period with a number of meetings taking place and properly documented. The last point on the slide there is that an individual can only make an unfair dismissal claim, whether for redundancy or otherwise, or a standard unfair dismissal claim, if they have 2 years service or a year and 51 weeks at the date of termination. However, there are circumstances where automatic unfair dismissal claims can be made with no qualifying length of service, and also discrimination claims don't require a length of service. So ideally, you want to go through a proper procedure in virtually every case, even if the employee in question has under 2 years service. Moving on to collective consultation. Now that's really important. It's a statutory obligation, and it kicks in if you as an employer are proposing to dismiss 20 or more employees within the period of 90 days or less. Also, it's worth noting that if you do lesser numbers in a number of different redundancy processes, tribunals will review that very closely to ensure that you're not doing this and you've not spaced it out just to avoid collective redundancy consultation obligations. There may be very good reasons that things change and you need to do it in different processes, but tribunals can look at that if these types of claims are raised. If there are between 20 and 99 employees, you need to do a minimum 30 days collective consultation. If you've got over 100 employees who are potentially redundant, it's 45 days collective consultation. The parameters and what you need to do is set out or are set out in the Trade Union and Labour Relations Consolidation Act 1992, provides for certain statutory information to be provided to the employee representatives or union representatives. If you've got a standing trade union covering all the employees, then the obligation is to consult with them. If you don't have a trade union covering all or some of the employees, then the requirement is to elect employee representatives and consult with them. There is also a requirement to provide an HR1 form notifying these potential redundancies to the Department for Business, Energy and Industrial Strategy. Actually, failure to do that is potentially a criminal offence. What you have to do when you are consulting is look at discussing the proposal for the redundancies, a rationale for it, and it's important to do that at a formative stage, and the decision hasn't already been finalised to go through with these redundancies. It has to be a consultation about the potential redundancies, and then there is also an obligation to consult on ways of avoiding or mitigating the redundancies as well. And this has to happen before individual consultation starts. The importance of this is not only in relation to making sure that a fair process is followed and you're ticking the boxes, and for employee relations perspective, the sting in the tail is that if you don't follow this and claims are raised, then the claims are worth up to 90 days uncapped pay per affected employee. So no minimum period of service, unlike in relation to unfair dismissal redundancies claim. The employees don't have to show that they've lost out on any money. They don't have to show any harm to them. What it is a punitive award for failure to comply with the obligations. And obviously, if you don't comply with these obligations as well, and unfair dismissal claims are also raised, then that makes it more difficult to defend these unfair dismissal claims. So really is a very important piece of legislation. And if you are thinking of going down the route of making 20 or more employees redundant, I would absolutely urge you to take specific advice, because it's easy to trip up on the process, and it can be quite a risky process if you don't know what you're doing in it. Lastly, I think, or second last actually, I've got a few more. I'm surprising myself about how much I've got to talk about redundancy. The next slide is about Acas redundancy guidance. Now, Acas, the conciliation service, released updated guidance in relation to redundancy in light of the pandemic. And that guidance includes that furlough scheme could be used as a method of or should be used as a method of avoiding compulsory redundancies. That's slightly at odds, one, with the fact that the furlough scheme is voluntary. No, as I've already said, no employer has to furlough an employee if they don't want to. And it's slightly at odds as well with the government's position. You'll remember that I think they've stopped using it so much, but there was a time when they were talking about viable jobs, and they wanted to keep viable jobs and protect those jobs, and that was for what furlough was for. So, as I say, it's slightly at odds with saying, well, you should put people on furlough, because there is an implication to that for an employer. The employee on furlough does cost the business money. It still has to pay the NI and pension costs. The employee will be accruing and entitled to take holiday, will be accruing length of service, which increases notice and statutory redundancy pay entitlement. So it is not fair, and it's not right to say that putting an employee on furlough is cost-free or cost-neutral for an employer. It does still cost them, and it still has implications for them. Therefore, it may be still appropriate to go down the redundancy route, even if furlough is an option. It could be challenged in the employment tribunal, not so much that it was not possible to make the dismissal, but the appropriate steps were not taken to avoid the dismissal. So if employers are preparing to make people redundant whilst furlough could be an option, it's worth preparing an argument as to why it's required in all the circumstances, because employees will likely ask the question as well. I am sure we are now all much more used to having our work interspersed with various video calls and not seeing people in person. Redundancy consultation and any other employee meetings can take place virtually. So that's absolutely fine. Teams, Zoom, whatever, old-fashioned phone call still works to show that you're consulting with the employees. The last point just on this guidance is that Acas, lots of employees know about Acas, look up Acas Guidance. So as an employer, if you're able to be aware of that guidance and know what that guidance says, that puts you in a good position for dealing with queries from employees. Moving on to the next slide. Alternatives to redundancy, as I touched on before, one of the key points in any consultation process is considering whether or not there are alternatives to making someone redundant. Alternatives, as I say, include in the slide there, reduction of hours, retraining, recruitment freeze, other roles, job share, something along those lines. Now, it's not going to be really necessary or applicable in every redundancy circumstance. Not all of these will apply. However, it's worth considering, is there anything else that we can do? If there's not, that's fine. Note it that it's been consulted upon and reviewed, puts you in a better position to defend any claim. Suitable alternative employment. Now, we get quite a lot of queries about getting quite worried about whether or not alternative employment is suitable alternative employment, and should it be offered, and how should it be classified. My advice always is, don't worry too much about whether you're calling it suitable alternative employment or not. Actually, there are very limited circumstances when you need to worry about whether alternative employment is suitable alternative employment for the purposes of the statute or not. It's only really when there's a dispute about redundancy pay, and if the employee turns down alternative employment, they can lose their redundancy pay entitlement if it is suitable alternative employment. Now, that happens pretty rarely, so it's not something when you're going through a redundancy process to get too fixated upon the term suitable alternative employment. Really, what you need to do in a redundancy situation is offer alternative employment, give details of all the available roles, allow them to apply for alternative roles. If there's a vacancy and there's more than one potentially redundant employee applying for it, you can have a competitive interview process, a selection process for that different role. You can potentially, and there needs to be a bit more care about this, if there is a vacancy and they want to go for it, but you don't think they're suitable, I think you should always at least give them the opportunity to interview for it before rejecting. If they're still not suitable after the interview, consider, can they be trained up? Or is there a support we can give rather than just rejecting them outright? If not, fine. But it's worth those thoughts before just saying, no, we're not letting you have this alternative. Because, again, it can be raised in an unfair dismissal claim. Finally, on redundancy, and it is finally this time, I'm going to talk very quickly on the next slide about bumping. It's a bit of a strange concept, and it feels a bit strange. It's basically making someone redundant whose role isn't at risk of redundancy to keep the person that would otherwise be made redundant. There's a case law example where there was an HR manager, and I think they were removing that HR manager role. They were at risk of redundancy, and there was a more junior HR role. Now, there was someone in that role. It wasn't vacant, but there was this more junior role. Now, the employer didn't consider moving that junior person out of that role and making that junior person redundant. And it was found to be unfair because they should have considered doing that. And the HR manager said, I would have done that more junior role, and I would have been happy to do that. Now, it does, as I say, seem a bit counterintuitive. It doesn't sit quite comfortably because you're making someone redundant who isn't or wasn't at risk of redundancy, and you would have to go through a process with them. So it does seem a bit strange, but it is a possibility and it should be considered. Most of the time it's unattractive because most people, it's normally a senior to a junior role. Most people wouldn't be willing to go to the junior role, and they would have to take those terms and conditions. But it is something that is a part of a redundancy consultation process, or can be part of a redundancy consultation process. So just to put that on your radar. Hopefully that's tackled a few points in redundancy. hit a few of the key elements. Certainly, it's a lot of the things that we've been asked about. I will now go on to touch fairly quickly, hopefully, on home working and flexible working. Now, current legal requirement in Scotland is pretty strict during this lockdown. There are only a certain number of reasonable excuses to leave home, one of which is to work if it's not possible to work from home. And there's also statutory guidance for employers about actually facilitating home working. Now, I'm aware that in the manufacturing sector, of course, you clearly need people in workplaces, and that is absolutely fair, and that has to be the case for work to be done. But the question is, do you need all people all the time? Particularly support functions, should they be working from home some or all of the time? Now, I think there is, there's been a massive shift in the past year, obviously, to a vast majority or a significant amount of people having to home work. I think there's a divergence in views. Boris Johnson has been quoted on a number of occasions saying as he sees this as temporary and people raring to get back to offices and other workplaces. Others, not so sure. I think the pandemic certainly showed that a much greater degree of home working is possible. But I think maybe the initial enthusiasm has waned and people miss being in the workplace. I think as well as the interaction with people, and even going on the basis that the IT setup is fine and as good as the workplace, which of course isn't always the case. I think there is a disconnect with colleagues. I think there is a real difficulty for training, progress, supervision for more junior members of staff. It's not necessarily a situation that I think needs to be completely perpetuated as one or the other, home working or workplace working. I think we might get to a position where there's going to be a hybrid between the two. Just very briefly, the next slide goes to talk about practicalities of home working. Employers, of course, still health and safety responsible for individuals when they're in the course of their employment, whether that's at home or not. I think increased hours. I saw something yesterday that said that despite the pandemic, there had been fewer sick days reported in Britain in 2020. I think there is a danger of, I think it's called living at work rather than working from home. So these are all sort of considerations that have to be taken into account. I've highlighted some others there. I won't spend any time on them because you'll probably be familiar with it. Potentially updating contracts, home working policies, and as I say, the key issues of management of employees. So because I appreciate, at least a significant degree of individuals in the manufacturing workplace won't be home workers, I won't spend too much time on it because I'm conscious of time here as well. Flexible working, I'll touch on that in the next couple of slides. That's a statutory right. The key point is that it's a right to request flexible working. It's not a right to have your request granted. We've seen a lot of these applications. I think we'll see more when workplaces go back in full. People will want to work from home, maybe full-time, maybe part-time. Changes to hours, changes to shifts are all potentially flexible working application subjects. So there is a statutory process that needs to be followed, and certain parameters that need to be met when making such an application. As I say, the it's really the right to request it, not the right to have your request granted. So an employer is absolutely perfectly entitled to refuse a request to flexible working. There are, however, statutory grounds, and it is only upon these statutory grounds that a request can be refused. Those are on the next slide. There has to be proper consideration. There's a 3-month time limit to they're actually, I've jumped ahead of myself. The obligation to or the refusal points on the following slide. We'll come on to them in a minute. As I say, it's a 3-month time limit for considering the request. The decision should be capable of being appealed, and the entitlement is to refuse is only on specified grounds, which are on the next slide. They're set out there. I'm not going to go through them. Suffice to say that claims under these regulations are relatively rare. What is more common and what is more dangerous for employers if they don't give due consideration is discrimination, whether if the request is on the basis of health condition, maybe disability discrimination, failure to make reasonable adjustments, or if it's childcare related, it may be about indirect sex discrimination claims. So I would certainly say that employers need to review the request and take it seriously and give it reasonable consideration. And even though it fits into one of the specific refusal points and abilities to reject a request, make sure you've got a good rationale behind it to tear and to defend any potential claims. Moving on then to the future ongoing requirements, I think health and safety considerations such as mask wearing and potentially social distancing will be with us for a while longer, at least. Who knows how long. We actually acted for a client in the manufacturing sector in an employment tribunal claim recently, which went to a full hearing and was actually reported in the press, so I can talk about it. But it involved a driver who was delivering to a client site. They had an obligation to abide by the client health and safety rules, and those rules required a mask to be worn in the driver's cab of his vehicle when on site, because I think they required to interact with the driver through the window. He needed to open his window and talk to staff. The driver actually refused to do so and said, mask wearing like this is not mandated by law, and certainly not in the situation where I'm in my own vehicle. The driver was ultimately dismissed for gross misconduct, and it was found to be a fair dismissal. So that's quite an interesting case that we were involved in, as I say, for one of our clients in the manufacturing sector. I think it's been billed as the first reported case on mask wearing and the requirement to do it in those circumstances. So I think we'll see probably more cases about that. And more complaints about that coming through. And as I say, because it's going to be something that's going to be with us for a while longer, and people may actually become more vociferous against it with vaccination, which we'll come on to. So it's a potential tension point there, I think. Finally, the other developing areas is obviously vaccination, which the rollout appears to be progressing very well. I think it's over 20 million vaccinated in the UK so far. I think over 1.5 million in Scotland. Of course, vaccination is not compulsory in law. Can employers justify it? Well, there's been a lot of debate about that. Can an employer force an employee to have a vaccination? Well, firstly, and most importantly at the moment, of course, it's not generally available. It's only available if you fall within certain parameters. So I don't think an employer could, at the moment, enforce anything like that. As we get to a position where it is more freely available, then that may be a consideration. But I think there are significant concerns. Unions have already made clear that they don't think that employers should enforce a regime where they require employees to get the vaccination, and that includes unions in the care sector and the healthcare sector, where really the need for vaccinations is probably higher. Certainly, any employer who wanted to insist or attempt to insist that vaccination was required would require to have some good justification, would need a risk assessment, would need to show why, in effect, their interference with the employee's private life is required to that extent. Also, discrimination considerations. Age discrimination at the moment, younger people can't get it just now unless they fall with one of the clinical groups that require it. Disability discrimination. Some people with some conditions may not be able to take the vaccine, to get the vaccine. So that must have to be an exception. Maternity, of course, I don't think any of the vaccines are necessarily approved for pregnant women yet. Religion may be religious beliefs that prevent the individual getting it. And philosophical belief, possibly stretching it, but there are clearly people who have strongly held anti-vaccination beliefs. Whether or not that is enough to be a protected belief under the Quality Act is another matter, but a variety of different beliefs over the past year have been held to be protected in case law. That includes a belief in ethical veganism, includes a belief in Scottish independence, for example. There's specific tests that need to be met. It needs to be genuinely held, a belief rather than just a viewpoint. But I could certainly see a possibility for claims being raised there. Also, I mean, just touching on, I suppose, a company that has pretty publicly announced their position is Pimlico Plumbers. I think they build it as a no jab, no job policy. As a company, I don't think they're shy of creating headlines. They've been involved in previous employment cases up to the Supreme Court level. Might be possible to do this for new employees, no unfair dismissal considerations. But as I say, discrimination doesn't need it doesn't need any length of service. So it can be, even applicants can raise discrimination claims. So I'm not sure if that's necessarily the way to go. It may be a more nuanced approach is appropriate. More difficult as well for existing employees. You'd have to justify it as a reasonable management request and show why it was required and why the vaccination was needed. Lastly, just quickly, data protection issues. I'm not a data protection lawyer, but you can well imagine that medical information like this is sensitive personal data. GDPR considerations about how it's stored, processed, who needs to know about it. Again, I can imagine there being issues raised about that in due course. There is some guidance about that from the Information Commissioner's Office. And interestingly, there's also Acas Guidance, which is effectively on encouraging, not requiring, but encouraging employees to get the vaccine, such as giving them paid time off to get it, and not counting any vaccine-related absences in trigger points for absence management. So I think that's certainly going to be something that we're going to see more of over the next 6 months or so as the vaccine gets more rolled out and more issues arise. That has been hopefully a fairly comprehensive rundown of a few key topics that we've been asked about. over the past 6 months or so. Happy to take any questions at all, or if people are happy to have heard enough from me, I quite understand that as well. So I don't think there seems to be any questions coming in. So in that case, I will sign off, and hope you found that useful. My details are at the end of the slides. If you've got any queries, anything arising from this, don't hesitate to get in touch. Pity I couldn't virtually see anyone, but good to have presented this to you, and I do hope you find it useful. Thanks very much.